Today's webinar will feature WELC Senior Attorney Tannis Fox, who will be sharing how we're leveraging state-level solutions to protect waters in New Mexico in light of federal rollbacks. A bit of background on Tannis. So Tannis joined WELC in 2020 as a senior attorney, and she focuses on protecting New Mexico's scarce water resources. Previously, Tannis was engaged in environmental protection work for the state of New Mexico for almost 20 years with the New Mexico Attorney General's office and as Deputy General Counsel for the New Mexico Environmental Department with a focus on water quality protection. She was the 2016 recipient of the Carl Sauter Water Protection Award from the New Mexico Environmental Law Center for her work protecting groundwater from copper mining. Prior to joining WELC, Tannis served as U.S. Senator Tom Udall's speechwriter, and Tannis graduated from Williams College with a major in economics, graduated magna cum laude from the Indiana University Maurer School of Law, and clerked on the U.S. Court of Appeals for the Ninth Circuit. So with that, I happily am glad to introduce Tannis Fox. So go ahead whenever you're ready, Tannis.
Hey, thank you so much, Michelle, for that nice introduction. I am Tannis Fox, and I'm based in Santa Fe, New Mexico. Thank you, everybody, for your interest in this important topic. It's going to be, to some extent, New Mexico focused, but has implications for nationally, and particularly in the West. And I'm first going to talk about, to sort of set the stage for the federal rollbacks that have been occurring over the last number of years, principally precipitated by U.S. Supreme Court decisions, some of which you all may be familiar or somewhat familiar with, and then talk about how those cases impacted New Mexico in pretty severe and significant ways, and what the state has done in response, in conjunction with advocates like myself to try to address the federal rollbacks. So we're going to first talk about the Clean Water Act, which is the nation's premier statute for protecting water quality in our nation. Congress first passed major legislation attempting to protect the nation's rivers, streams, and lakes in 1948, as far back as 1948. That act was called the Federal Water Pollution Control Act. It had pretty limited value. It only protected interstate waters, that is, waters that ran between states, but not waters that were wholly situated within one state, say like a lake, many lakes. It didn't prohibit polluting activities like discharges of wastewater to rivers. It did not set water quality standards or limit new sources of pollution. The federal government had very limited authority, and it was mostly an act to provide technical assistance, and it had limited enforcement authority, although the intent was to protect interstate waters. In order for the federal government to enforce, it had to have the permission of the polluting state. And so it wasn't very effective to protect the nation's waters. And really still at that point, dealing with water pollution was left to state and local governments. But those governments weren't effective in protecting their own waters either. They lacked the resources. They set ineffective or inconsistent standards between the states. There was inadequate enforcement. And so, the federal act wasn't protecting against interstate pollution. The states weren't protecting against intrastate pollution. But there was growing public concern for the nation's rivers, streams, and lakes. There were industrial discharges into rivers, municipal wastewater discharges into rivers, and that growing public concern really catalyzed with the Cuyahoga River fire. Uh, that in June of 1969. Um, that happened in Cleveland, Ohio. It was started by an oil slick that was under a train trestle. Here's a picture of it. And those photographs shocked the nation and galvanized Congress to act, to do a number of things environmentally, including establishing EPA in 1970. And then it was in 1972 that Congress passed very broad-based amendments to that 1948 Act that I talked about, resulting in what we now know as and what we call the Clean Water Act. Interesting to note that the House of Representatives passed the Clean Water Act 366 to 11, and the Senate passed it 74-0. Those days are gone. The goal of the Clean Water Act is to, quote, restore and maintain the chemical, physical, and biological integrity of the nation's waters. The Clean Water Act requires states to set water quality standards, minimum water quality standards. It has permitting requirements to permit the discharge of pollutants. It has what's called very frequently called Section 402, permits for what are called point source discharges into waters of the United States. Point source discharges are generally thought of as discharges that come from a pipe, like wastewater from a municipal treatment system. It also authorized Section 404 permits for dredge and fill activities. Dredge and fill activities are normally thought of as like construction activities where there's bulldozing or the like that is impacting wetlands or streams. The Clean Water Act, by its terms, protects navigable waters. And those waters in the Act are defined as waters of the United States, including territorial waters. And therein lies the problem that the Congress at that point in time did not define what waters of the United States are. The idea was, okay, you have navigable waters. Those are waters that historically can be navigated. But Congress, the intent was to make the waters that were protected more broad than just waters where you can, sail or have a boat in. But Congress didn't define the extent to which waters of the U.S. are broader than those waters that you can historically navigate, and that has been the source of conflicting Supreme Court opinions and conflicting federal regulations over time. In 1985, the Supreme Court decided a case called U.S. versus Riverside Bayview Homes and determined that wetlands that are adjacent to jurisdictional waters that are navigable waters, are subject to the Clean Water Act. The court looked back at the history of the Clean Water Act and looked at language of the Clean Water Act, which is to protect the biological, chemical, physical integrity of waters of the U.S., and understood that wetlands that are adjacent to those jurisdictional waters help protect and preserve the biological, chemical, and physical integrity of those jurisdictional waters, and said wetlands adjacent to jurisdictional waters are subject to Clean Water Act protection. The next major case that came along was in 2001, and that's commonly referred to as the Swank case. And that was a case where you had isolated ponds, ponds that were very far away from any other body of water, that the argument was they were protected. And the court there decided that they're not protected if they're isolated, and that the federal government couldn't use the Migratory Bird Act to gain jurisdiction. So you have sort of these, two competing ideas, or not competing, but two ideas. And one is, if you have wetlands that are adjacent to jurisdictional waters, they are protected. Wetlands and ponds that are isolated are not under the Clean Water Act. 2006, the Supreme Court decided the Rapanos decision. And this decision has really set the stage for, these dueling interpretations of the Clean Water Act since then. We'll see which interpretation, won out in the end. So in that case, the question was, does the Clean Water Act extend to wetlands that are close to man-made ditches that do empty into traditional navigable waters? And the court issued a 4-1-4 decision, which means that there's no majority opinion and no set standard. So on the one hand, Justice Scalia thought that these waters, waters that, in addition to navigable waters that are protected, must be relatively permanent standing or continuous flowing bodies of water that have a continuous surface connection to a jurisdictional water. So the idea is, well, the Clean Water Act protects water, so you have to have water. And you have to be able to see that water, touch, feel that water. It has to be close to it. It has to connect to a jurisdictional water. The problem with that analysis is it really doesn't hew to the language in the Clean Water Act, which says that the waters that are protected are supposed to protect the chemical, physical, biological integrity of these jurisdictional waters. Justice Kennedy had a more nuanced view of what constituted waters of the U.S., and that is, in this case, where the wetlands, if the wetlands had a significant nexus to waters of the U.S., and that is when a wetland alone or in combination significantly affect the chemical, physical, and biological integrity of the waters of the U.S. So Justice Kennedy is not only tying this standard to the language in the Clean Water Act, but also to the science underlying the act. And that is because we know that, these systems are connected, they're hydrologically connected, and pollutants, flow downstream. And so if a wetlands upstream is polluted, it can pollute downstream streams and rivers and lakes, and it can do that without necessarily having a continuous visible surface connection. But the sort of the battle between the relatively permanent and the significant nexus test sort of got set in 2006. And after that, there was a sort of a series of rulemakings where administrations, went back and forth between the two tests. The Obama administration adopted the significant nexus test. The Trump administration adopted the Scalia test, which was actually vacated by a district court in Arizona. And then in 2023, Biden came in and he adopted both tests to determine what are waters of the United States. That was in 2023. And in that same year, just after really Biden administration passed its rule, the Supreme Court issued its opinion in Sackett versus Environmental Protection Agency, which you might be familiar with. And in that case, the Scalia test held sway, and that was the test that was adopted by the U.S. Supreme Court in May of 2023. That case had to do with wetlands in Idaho that drained into a ditch. The ditch drained into a creek. The creek drained into Priest Lake, which is a navigable water of the U.S. So the issue was, were these wetlands that were variously connected to Priest Lake waters of the U.S. And Justice Alito and four other justices adopted the relatively permanent continuous surface connection. So what they were saying is the wetlands that the Sacketts were impairing had to be connected to a body that flowed relatively permanently, and there had to be a visible surface connection, all the time. And that wetlands that the Sacketts impaired didn't meet that test. Not everybody appreciates that the Sackett decision was a 9-0 decision in the judgment. That means that even the liberal justices concurred in the judgment that the Sackett wetlands were not protected under the Clean Water Act. Not only did they concur in that judgment, but they rejected in a concurrence written by Justice Kavanaugh that that they didn't want to adopt the significant nexus test. In that concurring opinion, they did not explain why. It's always kind of bewildered me why Justices Sotomayor, Kagan, and Jackson didn't support the significant nexus test. I can say, from years of litigation and being before courts often don't understand the science behind environmental laws. But in any event, it was a 9-0 decision. The implications for Sackett are wide. Sackett, in my view, ignores the science and ignores, as I've said, the basic goal of the Clean Water Act. The result is that the court's decision severely limits clean water protection over wetlands because not all wetlands have a continuous surface connection to a jurisdictional water. It likely precludes clean water protection over ephemeral streams and many intermittent streams. Ephemeral streams are streams that run only in response to a rain event. So, hard to meet the relatively permanent test. Intermittent streams flow seasonally on and off, so they may or may not flow relatively permanently, but the court gave no guidance on what that meant, what relatively permanently meant. So then there was another round after the Sackett decision. Biden administration really had no choice but to honor the court's opinion and adopt the Sackett standard in rule. The Trump administration this spring began a stakeholder engagement process over the definitions to be determined, what comes out of that stakeholder engagement process. I don't suspect it'll be good from my viewpoint, but we'll see. Sackett really has very severe implications for the arid West because so many of our streams are intermittent and ephemeral, and so many of our wetlands are not connected, do not have a continuous surface connection, to a jurisdictional water. Yet these bodies of water they're highly valuable. They filter pollutants and protect waters downstream. They provide habitat for many species, including endangered and threatened species. And they provide, really amazing recreation opportunities as well. So they have great value. Nationally, in 49 states, continental US and Hawaii, 59% of our stream miles are intermittent ephemeral. So, a great deal. And in New Mexico, because we're so arid, even more. Um, uh, Partner organization had this mapping done, and the mapping shows, see all the red. The red is our streams that are not are at risk from no longer being protected under the Clean Water Act. The blue are streams that still are. And in New Mexico, up to 95% of our ephemeral and intermittent streams are at risk of not being protected under the Clean Water Act. Similarly, for wetlands, up to 88% of our wetlands are at risk for not being protected under the Clean Water Act. So, uh, what can states do to protect their waters in light of the sort of very significant decrease in scope of protection under the Clean Water Act? Well, the first thing that states can do is to broadly define their waters that are protected under state law. So New Mexico, for example, has for years and has a very expansive definition in regulation uh, for what constitutes surface waters of the state. And you can see this, it's part of the definition right here. It's very expansive. It protects, to a large extent, the waters in New Mexico under state law. So that's the first thing states can do, is recognize that all these bodies of water do have value and should be protected. And then the next thing the states can do is protect all those waters. Not only through establishing water quality standards, but through filling in these gaps that were created by Sackett, where permits for point source discharges and permits for dredge and fill activity will no longer be issued by the federal government because these, because certain wetlands, ephemeral, and intermittent waters are not going to be protected. So when Sackett broke, New Mexico was in a really bad place because New Mexico had no state surface water permitting program. New Mexico, we had water quality standards, but that set, like I said, that, every body of water has to have X, water quality established. But we had no way to protect against discharges to these, up to 95% of ephemeral and intermittent streams, up to 88% of wetlands, any of the, point source or dredge and fill activities. And so it was a big problem. New Mexico had in the past only certified the federal permits to ensure that they met water quality standards. So on top of not having a state permitting program to protect these waters that were under state law protectable, but under federal law no longer, New Mexico was one of 3 states in the country that didn't have what's called primacy or delegation from the Environmental Protection Agency to implement the point source permitting program. So we were in a world of hurt, on all fronts. Even prior, though, to the Sackett decision, New Mexico sort of saw the writing on the wall and was worried that federal protections would go away, and, rightfully so, and started working on establishing a surface water permitting program. So in 2019, legislation was passed to establish regulations for surface water discharges. Money started coming in from the legislature for surface water permitting, and the monies that you see here were partially for surface water permitting. And so that was a start. Post Sackett, of course, Sackett was a wake-up call. And post Sackett, the governor of New Mexico, Governor Michelle Lujan Grisham, called to immediately begin identifying any regulatory gaps that we can fill at the state level. And then the next year, in recognition, of of the need in the state, the legislature appropriated a pretty hefty amount to begin starting a surface water permitting program. Um, Advocates like myself and other stakeholders had begun work as well years before on getting the money, on beginning to think about establishing a permitting system, a surface water permitting system for New Mexico. Um, the state agency responsible for water quality protection in New Mexico, the New Mexico Environment Department, established a stakeholder process to evaluate what needed to be done in terms of establishing these programs. And really, the several things that needed to be done in New Mexico is New Mexico needed to take control of the point source discharge program that EPA was running, for which, New Mexico was only one of 3 states that didn't have the authority to implement that permitting program. We needed that legislative authority. That had been tried twice before in New Mexico and failed sort of miserably because of industry opposition. And, we needed a state permitting program to permit these point source discharges and the dredge and fill activities. It was, I think consensus in New Mexico that the U.S. Corps of Engineers, which does the dredge and fill permits for the federal government, would retain authority over permitting dredge and fill activities for waters of the U.S., those waters that still remained. There was a lot of work over the last year or so by advocates, stakeholders, the State Environment Department, to get a bill in place this last legislative session. This had been tried, part of this had been tried a couple of times before. The stars kind of aligned here because New Mexico was in a very different situation post-Sackett, with so many of our waters at risk. The governor and the state agency were behind this effort. Advocates had been pushing the effort for years. And it culminated in a bill that was presented, filed in the New Mexico legislature this last session, in January and February, essentially is when our sessions are. So we have a 60-day session, in the form of a bill called Senate Bill 21. And again, the stars align with the sponsors, with the work that was done in the legislature on that bill. We knew we were never going to get industry support or even any Republican votes. But we did work with industry. We did talk with Republicans. There were some amendments that we agreed to during the course of the legislative session that didn't get their votes, but muted their opposition. And we passed Senate Bill 21 this session, and the governor signed it. And it's really a great victory, a great success story. The lead sponsor of the bill, who's the majority leader in the Senate, called it one of the most important bills that the legislature has passed in his 21 years in the Senate. So every once in a while, you get a big win, and we did. But there's still work ahead. And this is kind of you can't really read it, but it just gives you an idea of the timeline for next steps, because we won't have a program in place, tomorrow. We still have to go through rulemaking for both the Point Source Discharge Authority from the federal government and to establish the state program. That's going to be happening between now and next summer to get those rules into place. And once the rules are in place, the state can send a package to EPA for their approval for primacy. and we begin the permitting program. So it's anticipated that these programs will begin in 2027. In sort of closing, the irony here, or one irony here, is that the Supreme Court really eviscerated the 1972 promise of federal protection for the nation's waters. The states weren't doing a good enough job. It was recognized, and so Congress, passed a law that was intended to give federal protection broadly to the nation's waters, and that has been taken away. Congress is divided, and the likelihood of Congress rectifying the waters that are covered, under the Clean Water Act, rectifying the Supreme Court decisions it's not high. And so again, back to 1970, surface water protection is again left up to states. And Western states are hit the hardest. And so really the lesson is for us in New Mexico, is we have to work at the state level in order to protect these waters that are no longer protected under the Clean Water Act. And so we're moving forward aggressively, and I'm cautiously optimistic that in a couple of years, we'll have the tools in place to protect our waters. And I'm going to stop sharing now. And if anybody has any questions at all, I'd love to take them.
Thank you so much, Tannis, for all this critical work. And just again, thank you to all of you for showing up today, because Tannis wouldn't be able to do this work without our supporters. So much gratitude to you. Looks like Mark has a question, and I think there was one question in the chat, but go ahead, Mark, if you want to
I
go
would
ahead.
like to share with everybody, I was a team of 5 of us that got the Clean Water Act passed. And what we did, we saw people had a draft bill to save clean water so they could drink it. And other people over there had a bill to save clean water for fish to live in it. And we got them to sit down together in one room. And they combined the 2 bills into one bill. And then we had the advocates all over the country argue either for one reason or the other reason. It was a combination. Congress had to pass it because the people that cared about health, safe drinking, and also wildlife were together. I just wanted to share that. And that kind of applies right now. There's 2 reasons to save clean water and keep them both in mind: public health and nature and wildlife.
Well, thank you for that. Thank you for that work. Wow, that sounds amazing.
Yeah.
All right, we had a couple of questions in the chat. And one asking if Senate Bill 21 protects groundwater at all or just surface waters. And then another, I kind of tag these together, is that Julie was getting emails from Deb Holland for governor. Would she be a good protector of state waters?
The Senate Bill 21 does not impact groundwater. New Mexico actually has one of the strongest groundwater protection programs in the nation. And we have been issuing groundwater permits for decades. So we maintain standards. We have a very strong permit program. So we do have, we have that groundwater permit program that is acting to a certain extent as a model, for the surface water permitting program. And then I don't, I suspect Secretary Holland will be, a good protector for our environment. But, I don't know I haven't looked at any of her positions. She's sort of forming her positions now. She's actually speaking at a couple of water conferences in the near future, but so I suspect she would, but I can't really offer my opinion.
Thanks, Tannis. And looks like Dale, you have your hand raised if you want to, or under the name Dale, if you want to go ahead and ask your question.
I am Dale. Yeah, Tannis, in terms of groundwater, I know it wasn't the emphasis of WELC, but do you want to talk about what Senate Bill 21 did do for groundwater in terms of a cleanup program?
Well, oh, that's true. I mean, it did give some money for cleaning up groundwater, and it did extend CERCLA-like liability to owners and operators who have polluted groundwater. So it did, you're right, it did have that groundwater component.
Thanks for your question. Another one from the chat, here we go, was the $7.8 million allocated to the permitting process. The slide said 7.8. What do the permits do exactly?
Most of the 7.6 million was for establishing a surface water permitting program, which means, setting up staff, and also gives NMED funding for contracts if they need contracts to set up the program. And so that money, there was no appropriation this session because that 7.6 million was appropriated last session, and NMED still has to spend that money. So that'll be, that'll mean resources for establishing the program, like I say, either through staff, through contracts. And what was the other question? What will the permitting program actually do? It will analyze if somebody is going to have a point source discharge into a surface water or of the state, or if somebody is going to conduct dredge and fill activities that may impact a surface water, like wetlands or like ephemeral intermittent streams, then the potential discharger has to get a determination from the state that they need a permit. If they need a permit, then they have to go through a permitting process, and the permitting process makes sure that their activities don't pollute water quality below water quality standards. So just make sure that their activities, which are polluting activities, don't negatively impact, don't result in an exceedance of water quality standards.
Thanks, Tannis. Another question from Frank in the chat. Which constituencies in New Mexico were most important in supporting the passage of Senate Bill 21?
Which constituents? I think all the advocacy groups in New Mexico. We have a really strong coalition of groups who in New Mexico who are invested in water protection. And the sponsors of the legislation made sure that we were always at the negotiating table when the terms of the bill were being negotiated. The sponsors were not going to revise the bill in any way that, our hair was on fire and that we would strongly object to. Yeah, and as I mentioned, most of industry still was not supported, still not support the bill, and we got no Republican votes either in the Senate or the House or in any committee. And it went through 5 committees. But again, we negotiated some amendments just before it went to the Senate floor that I think didn't give away anything as far as we could see, but helped industry. And that did help things go more smoothly on the Senate floor and through the House.
Thanks, Tannis, and thanks for that question. Another question was, what was the role of local watershed councils in the fight, or how can we get ahead of these threats?
The coalition includes watershed organizations, environmental organizations like ours, and I think being a part of any of these organizations, being a member is helpful. And if you want to talk offline, be glad to do so about the various organizations that where you can volunteer and participate. But the more voices, the better. And certainly, I mean, in this particular piece of legislation, certainly, advocates played a big role in the framework and the design of this legislation.
Thanks, Tannis. Yeah, definitely echo that advocacy and just showing up right now is just so important and more critical than ever in so many different pieces of our work and just life in this moment in time. So another question just popped in. Do you believe that both state and federal laws and regulations are both useful for long-term water protection? Does one play a larger role than the other?
Yeah, I mean, both are important. And for 50 years, the Clean Water Act really did a very good job of protecting the nation's waters. And was the primary protector because it set minimum standards for states. States can can have regulations that are more stringent under the Clean Water Act, but not less. So, it set the base. It protected most of the nation's waters and really did an amazing job of cleaning up the polluted waters that we had, back in the 70s that, led to fires on rivers. But right now, at least especially in the West, the scope of the Clean Water Act has been so narrowed that really, for example, in New Mexico, it's going to be up to New Mexico to protect most of our waters.
Thanks, Tannis, and thanks for that question, Liz. I don't see any other questions right now, so if anyone has any final thoughts, yeah, Tannis just put her email in the chat, which is fox@westernlaw.org. Also feel welcome to email myself at loth@westernlaw.org. Oh, Mark, I see you have your hand raised, so if you want to go ahead and jump in, feel free to.
I wanted to share with you all, when I worked in Duluth, Minnesota, when the Federal Water Pollution Control Act was the Clean Water Act, our job was to determine what are toxic and safe levels of different metals and pollution, different kinds of pollution. And so we did it. I just wanted to share that that was a major accomplishment. We ended up, and what I did, my family said, "Why are you coming home, Dad, so late?" And I said, "Because I decided it shouldn't just be what causes them to die, but also prevents reproduction." So I had my species in the laboratory go through the reproduction stage. So the Federal Water Pollution Control Act was very important because it set the modern standards that are used for the Clean Water Act.
Thank you for that.
Yeah, thank you so much, Mark. And also before we go, I wanted to announce the winner of our stainless steel cup, and it was Teresa Greco. So Teresa, I'll message you offline, but get your cup mailed to you. So
Oh,
thanks.
goodness. Thank you. Oh my gosh.
Yay. It's always great when the person is able to still be on the call. So yeah, I'll shoot you a message and get that mailed out to you today. So So if there aren't any other questions, though, we can kind of wrap it up. And just want to say again, gratitude to Tannis. Thank you so much, Tannis. You're awesome. You rule and have done such important work and continue to do so. So very, very lucky to call you a colleague. And also just thank you so much to everybody on this call. WELC is a nonprofit, and we wouldn't be able to do all of this work without our supporters. So really, really appreciate it. Thanks for showing up. It's so important right now more than ever, like Tannis and I were saying, just to get involved and engaged in the times that we find us. So just gratitude to everyone. And Tannis, I don't know if you had any other final thoughts, and then we'll close the call.
No, just, thanks very much for your interest. And if anybody wants to have any offline conversations, you have my email. Love to talk with you.
Yeah, absolutely. Don't feel like a stranger to reach out. We always welcome questions. So with that, hope everyone has a great rest of your day, and thanks again. Bye.